It started with 2 cameras. That's all. 2 simple, battery-operated security cameras mounted on the front of a house, pointed at the driveway, watching over their cars. Nothing unusual. Nothing threatening. Just a couple of homeowners who wanted to make sure their vehicles were safe at night. Now, here's what made these cameras different from your average Ring doorbell setup: they had a special feature. You could go into the app and literally gray out sections of the camera's field of view. Draw a digital box over any area you didn't want recorded, and when motion happened inside that grayed out zone, the camera simply wouldn't activate. It was like those areas didn't exist. So when our homeowners, let's call them Mark and Sarah, installed these cameras, they were careful. Really careful. Part of the camera angles did overlook portions of 2 neighbors' properties, 1 backyard on the left, 1 side yard on the right. So what did they do? They immediately grayed out both neighbors' entire properties. Plus several bushes on their own property, just to be extra cautious about battery life. Then they did something most people wouldn't bother to do: they went and told both neighbors. Face to face. Showed them the camera angles. Showed them the grayed out zones. Said, hey, we just wanted you to know, we're not recording your property. Here, look for yourself. The neighbor on the left, let's call her Susan, she was totally cool about it. She actually said she didn't care whether they grayed out her area or not. It's fine, she said. I trust you. But Mark and Sarah kept it grayed out anyway. Battery life, remember, the neighbor on the right, well. Her name wasn't actually Karen, but for this story, that's exactly what we're calling her. Because if there was ever a person who earned that name, it was Karen. Karen was on the HOA board. And the moment Mark showed her the camera angle and the grayed out zone over her property, which was just an FYI, by the way, not asking permission, Karen's face went tight. Her jaw clenched. And she said 4 words that would kick off a war: take them down immediately. Or you will regret it. Mark didn't take them down, and yes, he would come to regret it. But not nearly as much as Karen and the HOA board would. About a week later, a certified letter arrived. Official HOA letterhead. The kind of envelope that makes any homeowner's stomach drop. Mark opened it and read, violation of HOA bylaws. His eyes scanned down. What bylaw? What rule had he broken? There had to be something specific, right? Something about cameras? About surveillance? About privacy? Nope, the bylaw they cited. Nuisance to your neighbors. That's it. A catch-all. A vague, deliberately broad rule that could mean literally anything the board wanted it to mean. Your grass is too long. Nuisance. Your Christmas lights are still up in January. Nuisance. You painted your door the wrong shade of beige. Believe it or not, nuisance, there was no specific bylaw preventing the placement of cameras. The HOA board had dug through their entire rulebook and this, nuisance to your neighbors, was the best they could come up with. One neighbor. One neighbor had complained. And that one neighbor happened to sit on the board that was now sending violation notices. Mark and Sarah were frustrated, but they weren't panicked. They knew they hadn't actually violated any real law. So they drafted a response. A calm, professional letter detailing exactly how they were not violating any bylaws, not violating any state laws, and politely asking the HOA to cease and desist. They mailed it off, thinking that would be the end of it. Reasonable people, when presented with facts, would back down, right? The response came back faster than expected. And it wasn't what they were hoping for. The letter from the HOA board didn't address any of their points. It didn't engage with their legal arguments. It was one line, dripping with arrogance: the HOA has the right to enforce these bylaws. Try to stop us, if you think you can. Mark read that sentence 3 times. Try to stop us, if you think you can. He looked at Sarah. Sarah looked at him. And in that moment, something shifted. The frustration turned into something else. Something sharper. Okay, Mark said, setting the letter down on the counter. That's exactly what we're going to do. They didn't know exactly how yet. But they had a new mission. A singular goal that would guide every decision from this point forward, cost the HOA as much money and time as humanly possible. Now, you have to understand something about homeowners associations. They operate on a very specific kind of power. It's not government power, they can't throw you in jail. It's not corporate power, they can't fire you. It's a weird, in-between, quasi-legal authority that relies on one thing above all else, compliance, when homeowners just comply. When they get a violation notice and they fix the problem and they move on. That's what keeps the machine running. That's what makes board members like Karen feel powerful, but when someone pushes back. When someone says no, and means it. The system starts to creak. The cracks show Mark and Sarah weren't just saying no. They were saying, we're going to make this so expensive and so painful that you will never, ever do this to anyone again. And the HOA board walked right into it, because here's what the HOA did next, they hired a lawyer. A real, actual, billing by the hour attorney. Specifically to fight Mark and Sarah. Over 2 cameras. To Mark's knowledge, and he checked, this had never happened to any other resident in the entire community. The HOA had never hired an outside lawyer to fight a single homeowner over a single violation. But they did it for this one. Why? Because Karen pushed for it. Because the board had publicly declared, try to stop us, and now they had to follow through. Their egos were on the line, and every hour that lawyer worked. Every email they drafted. Every phone call they made. It was all billable. All coming out of the HOA's annual budget, the annual budget that was approximately $25,000. Total. For the entire year. To maintain common areas, pay for landscaping, community events, insurance, everything. Mark did the math quickly. A lawyer at $200 to $300 an hour, if he could just keep the battle going long enough, this was going to hurt. That he grabbed his laptop and started typing. This is where Mark's strategy gets beautiful. Most people, when facing an HOA lawyer, would either fold immediately or hire their own lawyer to fight back. Both options are expensive. Both options are stressful. Mark took a third path. He reached out to a friend. An attorney friend. Not to hire, just to ask for advice. How do I make this process as long and expensive as possible for them, without spending money myself? The friend smiled and said, postpone. Question everything. And always, always follow up. So that's exactly what Mark did. The HOA's attorney would send a letter demanding the cameras be removed. Mark would respond with a series of questions. Not aggressive questions, just thorough ones. Could you please clarify which specific subsection of the bylaw is being cited? Could you provide documentation of board meeting minutes where this violation was discussed? Could you explain the appeals process in detail? Every question needed an answer. Every answer needed another letter. Every letter was 15 minutes of billable time, then Mark would respond to the answer with another question. And another. And another. Over the course of 4 months, there were over 100 emails back and forth between Mark and the HOA's attorney. 100 emails. At roughly 15 minutes each. For an attorney charging $200 to $300 an hour. You do the math. By the end of those 4 months, the HOA had racked up over $4,000 in legal fees. Fighting 2 cameras. 2 cameras that were grayed out and not actually recording anything problematic. $4,000. Out of a $25,000 annual budget. But the emails were only half the strategy. Every HOA violation process eventually leads to a hearing. It's like a mini trial. The homeowner stands before the board presents its case, the homeowner defends themselves, and then the board votes. Almost always, the board votes against the homeowner, because the board is both the prosecutor and the judge. Mark's goal was never to win that hearing. He knew he wouldn't. The board was stacked with Karen and her allies. His goal was to delay that hearing. For as long as possible. Why? Because every month the hearing didn't happen was another month of legal fees. Another month of emails. Another month of the meter running. The first hearing date came. Mark's attorney friend helped him draft a formal request for postponement. Reason? We require additional time to prepare our defense and gather evidence. Reasonable. Professional. The kind of request that's hard to deny without looking unreasonable. Postponement granted. First date, crossed off. 3 weeks later, the second hearing date approached. Mark filed another postponement. This time, key witness unavailable. The witness was the friendly neighbor, Susan, who was happy to say she'd